Greetings, everyone. This is Richard Solomon. This is Taking Care of Business. And this week, my very special guest is attorney Ken Rubinstein. And our topic today is asset protection, especially asset protection for the small business owner. Welcome to the show, Ken. Thank you for being with us.
Thank you for having me.
All right. Grab a pen out there, 212-888-6600 and assetlawyer.com. Ken, what are some of the compelling reasons for asset protections, especially for small business owners?
Well, the bottom line, most important reason for asset protection is because we live in the most litigious society in the world. The chances are that everybody will get sued at some time or other. Business people, the chances of them getting sued are higher than what I just said. And if you want to protect what you've worked so hard all your life to make and be able to leave it to your children rather than have somebody take it away from you, you need to protect it.
All right, let me ask some of the obvious questions, even though I kind of know the answers. Why isn't just having insurance just good enough?
Well, there are two reasons for that. Reason number one is because insurance is a kind of a target. If somebody knows you're insured, they know that an insurance company is going to pay, it's all the more reason to sue you. The second reason is because there are lots of things that are not covered by insurance, that are specifically excluded. For example, environmental hazards are excluded from insurance. Intentional torts, if you do something wrong intentionally, for example, if you defame somebody, that's excluded from insurance.
Now, what are the tools available to small business owners, and which tools are good before there's the onset of litigation, and which tools work when you may be already served with some kind of notice, summons, or subpoena?
Well, when we talk about tools for asset protection, the first thing that we need to understand is good, effective asset protection has to be done legally. It doesn't mean you hide your assets. Hiding assets doesn't work, and it's not effective asset protection. The tools for proper legal asset protection is to use the asset protection laws that are on the books in virtually every one of the 50 states.
Okay, what are those tools?
Well, in New York, it's the New York Revised Limited Partnership Act. That same law exists in every state. It's basically the Revised Uniform Limited Partnership Act that was adopted by the Uniform Laws Commission and given to all of the states and then enacted into law in all of the states.
All right, so how does this law actually protect you?
Well, this law says that if you form a limited partnership and transfer your assets into the partnership, the assets that will be in the partnership are no longer legally your assets, although you control them as general partner of the partnership and have the benefit of them. They're legally not your assets, and because they're not your assets legally, they are not available to a personal creditor of any partner. It's kind of like saying if you own stock in General Motors, you don't own the factories. And because somebody gets a personal judgment against you, they can't go out into the factory and take 2 cars off the assembly line. You own the stock, but you don't own the assets of the company.
Okay. So what is the mechanism for invoking that law into your business so that it transforms the business assets? So let's say I'm a plumber or a mechanic, or I have an auto body shop or something like that. What do I do with my business, and how do I take that business and protect the assets of that business?
Well, you want to protect the assets of the business, but you also want to protect your personal assets. You've made a living. You made profits from that business. Those profits went to buy your home, to build your savings accounts, to buy things in your home, etc., and you want to protect those too. So the first thing we have to do is, A, we have to analyze what are your personal assets that need to be protected. Most important, you want to protect your home from being attached by creditors. And two, what are your business assets? Okay, if you're a plumber, let's say that you have
a truck,
two or three trucks.
Yeah.
Okay, let's say that your business has been pretty successful, and you bought an office building or a warehouse where you garage the trucks and where you store your tools. You want to protect that real estate.
Okay, and then what do you do as far as structuring the business in terms of the ownership of the business, separating your assets from the business assets, things with employees? How does all that work?
Okay, you want your business to be set up as either a corporation or a limited liability company, an LLC, and you want the shares of the business to be owned by a limited partnership.
Okay.
In addition, you want, let's say, the warehouse that I said, or the garage, to be owned by a different limited partnership, which will then lease it to your business. You want another partnership to own your home and your bank accounts and savings accounts and so on. Now, each of these partnerships, who are going to be the partners? Well, it can be you, your wife, and your kids. Therefore, they're called family limited partnerships. But under the law, they're limited partnerships covered by the New York Revised Limited Partnership Act, which says that the assets in each of these partnerships are legally not your assets, even though you control them, and cannot be attached by a personal creditor.
Okay. Now, I assume in the partnership the minimum is 2?
Yes,
and
at
then
least 2 partners.
Is there any upward limit?
No.
Okay. So the assets are now, I guess, segregated into different components. What is some of the paperwork compliance that goes with all of this? Because one of the things I hear from people is, "Oh my God, there's so much paperwork and all this other stuff." But can you kind of straighten out that misperception?
Well, we prepare all of the paperwork. The partnership has to be registered. You have to choose a state to register the partnership in. There has to be a partnership agreement. There has to be a partnership certificate. There has to be a schedule that lists the assets that are in the partnership. And there have to be documents that transfer the assets into the partnership. So, for example, if we're transferring real estate, the garage that I mentioned, or the warehouse, or your home, there will be a deed deeding the property to the partnership. If we're transferring accounts or we're transferring stock of the business, there are going to be bills of sale.
Okay. Now, I've heard from some people that they're uncomfortable with changing the deed of their home, either because of the mortgage issue or for other reasons. Could you address that for us?
If you don't deed the home into a partnership, it's not going to be protected.
Okay.
So you have to address the reason for the discomfort. Transferring the home into a family limited partnership where you and your wife or the partners in the partnership doesn't trigger the due on sale clause in a mortgage. It's not a sale to a third party, so it doesn't make any difference to the bank. As long as you're current on the mortgage, the bank's not going to care.
Okay. Now, when it comes to sort of the paperwork compliance, does each of these partnerships have to file their own tax return?
Yes.
Okay.
Every partnership files a 2-page informational return. It's form number 1065. It doesn't pay any taxes. Any income flows through to you. The partnership issues, together with the form 1065, a Schedule K1, which shows what your percentage of ownership in the partnership is, and therefore what percentage of the partnership's profits belong to you, and that gets attached to your 1040.
Okay. So does each separate partnership get its own tax identification number?
Yes, it does.
Okay. There's a misconception out there. These partnerships are not necessarily engaged in business, are they?
No.
Right.
The partners, they can be.
Right, but the ones that you're talking about, because like the plumbing company is really
the plumbing
business.
company still is a plumbing company,
Right.
and it's in the business of providing plumbing services. The partnership merely owns the shares of the plumbing company. It's not engaged in business, just as if you own shares of General Motors, you're not engaged in car manufacturing.
Okay. So let's say that the business is sued, and they sue you personally because you see that a lot. How does this asset protection format actually do the work of asset protection?
If you've done this properly and before you got sued, then number one, if they win the lawsuit, they can't take your home because it's in a limited partnership. It's not yours. They can't take the garage that we talked about or the warehouse. They can't take the shares of stock. They can't take the business away from you. So future profits of the business will still flow up to the partnership and be protected. They can't take your savings accounts. All of those things are protected. They can't take them.
Are there certain things that are automatically protected by the law, such as retirement savings accounts?
Yeah, IRAs, 401ks, other qualified retirement accounts are automatically protected by the law. So are any assets that are in a life insurance policy.
Okay. And that's just a matter of public law?
Yes, that's a matter of New York law.
Okay. Now, I know for those out there, I'm Richard Solomon. I'm an attorney also. And I know that, at least in New York State, there's certain exemptions, even when you're a judgment debtor, when someone has won a lawsuit against you. There's a certain minimum amount of money they can't take from you. I think the first X $1,000 in a bank account is exempt. They can't take child support money. They can't take Social Security disability money. Certain things they can't take. But one question for you, Ken, is how important is it to sort of title your bank account so it's really clear that some of the monies that you have, like a payroll account or this or that, is actually exempt from capture in case you're exposed?
The only bank accounts, the only monies that are exempt from capture in New York are Social Security, retirement accounts, as we said before, disability payments. That's it.
So I guess you would call it, Richard Solomon Social Security income.
Yes, and what you have
account.
to make sure is that you don't mix that money with other money. If you deposit your Social Security check into a checking account that has other money in it, it's impossible after that to tell which money is the Social Security and which money is the other money, and so it's all attachable. But if the account is, for example, a Social Security direct deposit account, or an account where you only deposit the Social Security checks, no other money goes into that account, so that the account keeps its identity as Social Security proceeds, then it would be exempted.
All right. We are talking to Ken Rubinstein, 212-888-6600, assetlawyer.com. This is Richard Solomon. The show is Taking Care of Business. We'll be right back. Keep it locked here on Taking Care of Business.
What I really need is some kind of affection.
Welcome back. This is Richard Solomon, Taking Care of Business. Our special guest is Ken Rubinstein. There's an expression, when 911 has a problem, who do they call? Well, when I have a problem. I'm usually a lot of people's 911. Ken is my 911. So
Thank you.
So I know a lot of lawyers out there, and there are great lawyers out there, but amongst the people I have the utmost respect and admiration for, and who is my 911 person, it's definitely Ken. And he was kind enough to share some time and wisdom with everyone today. So really appreciate him being with us. He has a website chock full of great information. It's assetlawyer.com. You may surf the internet and look for a lot of things on asset protection, but in many ways, Ken is a pioneer, wrote the book, and has a lot of great achievements out there in the world of law. You may not know them, but I know that he's the go-to guy. So we were talking before about commingling, and we all know that, as lawyers, commingling is a huge problem. Not to commingle payments. You were saying before about the Social Security payment shouldn't go into some other group of payments. Talk about this with respect to the payment of whatever by check coming from the right account so that the partnership integrities are not destroyed.
Yeah, look, the partnership is a separate legal entity, and it has to be kept at arm's length and respected as a separate legal entity. That means that you don't use the partnership bank account as your own personal piggyback. You don't pay for purely personal expenses, food, clothes, etc., out of a partnership account. If you need money from the partnership, you write a check from the partnership. That can either be called a distribution from the partnership. It can either be salary to you for managing the partnership as general partner. It can be a loan from the partnership. But you write a check to yourself, you put it into your own account, and then you go and pay your personal expenses with it. The partnership account is used to pay for partnership expenses. So what does that mean? That means if the partnership owns your warehouse, if you're going to make repairs on the warehouse, you're going to pay out of the partnership account. If you have to pay the real estate taxes on the warehouse, you're going to pay them out of the partnership account. If you have to pay insurance on the warehouse, you're going to pay it out of the partnership account. You're not going to buy your groceries out of that account.
Now, do you recommend using different banks to keep everything squared away? Because that's what I do.
You can. I mean, there's no downside to using different banks, except that you have to keep track of them and run around a little bit. But if you don't want to do that, you can keep the various partnership accounts in the same bank. Just make sure that there's separate accounts for each partnership.
And what I tell people also is to use different colored checks so they can't make a mistake.
Sure.
Whatever you can to keep everything squared away. Now, commingling tends to trigger in the legal world the famous phrase of fraudulent conveyance. Let's talk about that. What is the danger? What are the red flags? And how do you protect against that?
Fraudulent conveyance means that you did something to your assets with specific intent to hinder a creditor from reaching those assets. So the first thing that you have to understand is if somebody becomes your creditor, then whatever you're going to do after that might be called a fraudulent conveyance. So you want to set up your asset protection plan before you have a creditor, not after you get served with a summons and complaint, or after somebody sends you a nasty letter and says, I'm going to sue you. You want to set up your partnerships, your asset protection plan early on in your business before anything happens.
I actually tell people that they should do it the day they incorporate.
Sure, that's an excellent idea.
Because this way you're clean from the beginning. But
You can't buy fire insurance after you've had the fire.
Very true. So you have so what is considered, like, I'll give you a typical scenario. I will get a call, someone got sued, and the question is I have a lot of equity in my house. Should I just sign the house over to my wife?
No, that's a clear fraudulent conveyance.
Right. Explain to our listeners why that's not a good idea. And
Well, because there are tests to determine what's a fraudulent conveyance. And one of the first tests is a transfer to an immediate family member, like I'm signing the house to my wife. The second test is a transfer without full and fair consideration. In other words, I transferred the house and I didn't get anything back for it. And when you transferred it to your wife, you didn't get anything back. Under the law, love and affection doesn't count.
So let's say, for example, is there also, in some instances, wouldn't that also trigger a tax consequence? For example, person gives his cousin the house just to get it out of his name.
Yeah, transfers between spouses are not subject to gift tax. Transfers to anybody else, give the house to your child, that can trigger a gift tax.
Right. So let's say a house is worth $800,000, and there's, I don't know, $600,000 in equity, and you go over there and you sign a deed because you're panicked. Does that mean that the recipient has $300,000 worth of income all of a sudden?
No, it's not income.
Or a gain,
it's
rather.
It's a gift.
Yeah.
It's not a gain, it's a gift.
Okay.
And you, the one who gave it, the one who signed the house over, owes the tax.
Ah.
You have to file a gift tax return together with your income tax return and pay the gift tax.
And I'm sure that's quite substantial.
45%.
Wow. And what is the magic number right now in 2015 for a gift before you have to file a gift tax return?
There's an exemption, a federal exemption of $5,320,000. So you can give up to $5,320,000 in cash or assets during your life.
To who?
To whoever you want. You have to file a gift tax return, but you'll be exempt from gift tax.
Gotcha.
New York State, the exemption is much smaller. It's about $1 million.
Oh, okay. So it's so important to track all this.
Right.
All right. So moving along to asset protection, when you didn't listen to this show, or somebody didn't come across one of your interviews at Bloomberg or some other featured news outlet, and they've got a huge problem. Let's say they're a doctor or a securities broker and they're being sued. Are there still some tools available in terms of asset protection for those people?
There are, but the tools are much more complicated and they're much more expensive. So in certain cases, when transferring the assets into a limited partnership, will clearly be considered a fraudulent conveyance because you already have a judgment against you, or it's on the eve of a judgment. Then the only thing you can do that will be completely effective, that will still work, is to set up an offshore trust in a jurisdiction that will not recognize U.S. judgments or court orders and transfer your assets to that offshore trust. But you need to understand a couple of things about that. One, you have to physically move the asset offshore, which means you can't do it with real estate. You can't pick up real estate and move it offshore. Simply sending the deed to sit in the vault of Trustee offshore is not going to do it. So you have to turn the real estate to money, because that's really the only thing you can move.
And the bigger the real estate, the harder it is to sell it in an instant.
Well, you either have to sell it or you have to mortgage it and move the mortgage proceeds offshore. Right. The other thing that you need to understand, in order for this to work, you have to give up complete legal control to a trustee offshore. If you keep control over the trust, a court can make you bring the money back. It's only if you have no control that a court can't make you bring it back.
I've heard stories where judges have went ballistic on this, and they tell the person who's moved the assets to bring them back, and then of course the trustee says, since you're under duress, I'm not going to acknowledge this, or we don't follow U.S. law. How does that work, and what does that do for the person who's in the squeeze?
If the trust was properly drafted, if this was done correctly by an attorney who knows what he's doing, then you'll be able to say to the judge, Judge, I'll do exactly what you wanted me to do. Here's a letter to the trustee. I'm sending it certified. The trustee 2 weeks later answers back, as you said, I'm not sending the money back because you didn't send this letter to me voluntarily. You did it because the court made you. And if you can say to the judge, Judge, it's impossible for me to bring it back. I don't have control over the trustee. The judge can't do anything to you. Impossibility is a defense to contempt.
Right, because that's the big problem, is that people are worried about the threat of the court to...
There are lots of cases where courts put people in jail for civil contempt. They said, you're going to jail until you bring the money back. But that only happened when these trusts were not drafted properly, and the judge found that the person actually had control over the trustee. Where you don't have control over the trustee, the judge cannot put you in jail for contempt.
Right. So let's move to a couple other topics, speaking of offshore. I know that in some of our conversations in pre-production, the idea of Swiss bank secrecy is long gone, long gone. And people that actually don't really know that. The word it doesn't seem to have gotten out. Let's talk a little bit about foreign bank accounts, foreign bank account reporting, our government's stance on that, and bank secrecy in general.
Mm-hmm. There is no law in the United States that says you can't have money overseas. The law simply requires you to disclose that to the IRS and to pay income tax here on any income you earn overseas. But if you comply with the law, if you make the proper disclosure, you can have as many accounts as you want overseas. There's nothing wrong with that.
Now, one way to, I guess, not to have to pay the taxes is just get a non-interest account, just like a holding account?
Yeah, if you simply have a checking account overseas and you're not earning any interest on it, then there's nothing to pay tax on. But you still have to disclose the fact that you have the account. There are special forms that have to be filed each year. They're called FBAR forms. And you have to disclose that you have the account. There's also a question on your income tax return, Form 1040. It's Schedule B, question number 7. Did you have signatory or beneficial ownership over any foreign account that totaled in the aggregate, in case you had more than one account, $10,000 or more at any time during the year, even for one day? If so, check the box yes and file the FBAR form.
Okay. Now, I assume that there are huge consequences for not reporting foreign bank accounts.
Yes. If your failure to report was willful, the penalties can be as high as $100,000 or 50% of the value of the account, whichever is greater, for each account for each year that you failed to report. If the failure to report was non-willful, you just didn't know, the penalty can be as high as $10,000 per account per year.
Well, it could add up.
Yes.
Are there any criminal penalties that attach?
Yes, criminal penalties can attach if you earned income overseas, whether it's in the account or not in the account, and you willfully decided not to disclose that to the IRS and pay tax on it.
Now, I know from reading a lot of your website material and articles that your office has generated that the IRS has been fairly aggressive in this endeavor.
Yes,
Yeah.
They've prosecuted hundreds of people, and not only did they prosecute the people, but if they found out that some foreign lawyer or some banker helped the people in not disclosing the accounts or hiding their income, they've prosecuted the lawyers and the bankers overseas and had some of them even extradited to the U.S.
Wow. Now, how does the IRS find this information out? Not that I'm,
Every bank in the world, except for maybe Cuban banks or Libyan banks
or North Korea.
or North Korean banks. Every bank in the world has to disclose to the IRS information on all accounts that have a connection to a U.S. person.
All right, so the whole Swiss bank numbered account that you see in the movies with Humphrey Bogart and airplanes,
that was a myth ever since 1991.
Wow. So for people who are out there and they want to come in, is there a way to come in from the cold and
Yes, there is a voluntary disclosure program. It's kind of a partial amnesty that people can apply for. You need an attorney to make the application for you and to provide the information to the IRS. And if you're accepted into it, then you have to provide your tax returns going back 8 years. You have to amend your tax returns for any undisclosed foreign income. You have to file the FBAR forms, and you may have to pay a penalty as high as 27.5% of the highest balance in your foreign accounts during the 8 years. Now, there are a list of about 12 banks around the world that they're on a special list where those banks, the IRS has previously announced that those banks are under U.S. investigation for maintaining undisclosed foreign accounts of U.S. persons. And if your accounts are in any one of those 12 banks, the penalty is 50% instead of 27.5%.
Wow.
Now, for some people, if they had no income in the accounts, there is no penalty, and you don't have to amend returns. You just have to file the FBAR forms going back for 6 years. There's also a streamlined program. For some people, they just have to pay the back taxes, but no penalty. For other people, it's pay the back taxes plus a 5% penalty. So it depends really on the facts of your situation.
Right. I'm sure there's every kind of situation where you've inherited money from a relative and whatever, and then they put the account in your name to, I guess, owning companies in foreign countries and having, bank accounts. I'm sure there's a whole mix of things out there when it comes to that.
Correct.
Wow. This is the end of segment 2. This is Richard Solomon. The show is Taking Care of Business. You can catch us up on YouTube at youtube.com/user/TCBRadioWCWP. My guest is Ken Rubinstein. He is with the law firm of Rubinstein and Rubinstein in New York City, in Manhattan. You can give his offices a call at 212-888-6600. You can check out his website at assetlawyer.com. We will be right back after this quick timeout.
What I really need, some kind of affection.
Richard Solomon, Taking Care of Business with attorney Ken Rubinstein on asset protection. Continuing in our discussion on asset protection, especially for the small business owner, let's talk about two touchy topics for people emotionally. One is estates and our eventual demise, and the second is the demise of potentially a marriage, both of which involve asset protection and possibly impacts on business. Let's talk first about estate planning. How does estate planning fit in with asset protection?
Well, You want to make sure that the assets that you've worked hard for all your life go to your heirs, to your children, grandchildren, without the government taking as much as half of the assets when you die. And the way to do that is to do proper estate planning. You also want to make sure that the assets will go to your heirs quickly, quietly, easily, without long, drawn-out, expensive court proceedings where you have to hire lawyers and pay them to spend a lot of time in court. In other words, you want to avoid probate on your estate when you die. Again, that's a core goal of estate planning. So, how do you make sure that there are not going to be any taxes on your estate when you die? Well, first of all, you need to understand, under the current law, when you die, approximately $5,320,000 worth of your estate is exempt from federal tax. In New York, the exemption is about $1 million. It's going to go up slowly to $2 million, and then ultimately match the federal exemption. But right now it's about $1 million. Your spouse has the same exemption. So therefore, you want to do at least a revocable family trust so that when you and your spouse die, there will be two exemptions that apply and not one. See, if you don't do the trust in a typical situation, let's say husband dies first, wife inherits everything, there's no tax because there transfers between spouses, even by inheritance, are exempt from tax. Then wife dies and the children inherit the estate, but only with the wife's exemption. If you do a proper family trust, you'll keep two exemptions, yours and your spouse's.
That's actually huge when you think about it.
Yes, of course.
Yeah.
It doubles it from
Yeah.
$5 million to $10 million. Also, by putting your assets, and the assets can be your limited partnership shares if you put everything into the limited partnerships that we talked about before. If you didn't, the assets would be your home and your accounts and your business and so on. If you put them into the trust while you're alive, you have no estate to go through probate when you die.
And just so you know, probate is not easy. I have an uncle who was an older guy. He fought in World War II. He was in the Marines. And he kind of did a will, one of those very simple wills. And my aunt died first and he died second. And the truth is, because there are some things that are being probated, it's been and his children predeceased him. It's actually been very complicated, very, very complicated. So for all the people out there, you really do want to avoid probate. I'm a lawyer, my brother's a lawyer, and this was our uncle, but he did it his own way, and that's his prerogative. But the aftermath of that has been long, complicated, and expensive, and really, sadly, it cost a fortune that really didn't need to be paid. And that was the sad thing.
When I lecture on this, I put a little joke into my lecture. I say every will that a person writes has a clause written in invisible ink. It says, I hereby leave my lawyer at least $25,000.
Yeah, it's true. And something for the government.
Yeah. Right.
All right, so continuing on with the whole estate thing and probate and avoiding probate.
Well, proper estate planning means sitting down with an estate planning attorney and seeing what is your estate, everything that you have. Do you have life insurance? What are the death benefits? Because if you own the policy, the death benefits will be taxable in your estate. Do you have IRAs, retirement plans? You have to think about that. You have to look at everything, put it all in the pot and see what is it all worth. Does it exceed my exemption? Will it grow between now and the time that I might die? What is the expected value of all of this down the road? And then do the proper estate planning. maybe a family trust is all that you need to do. Maybe you need to do, besides that, an insurance trust so that the death benefits won't be taxable in your estate. There are all kinds of other tools that we have as estate planning attorneys for very large estates. We have qualified personal residence trusts. We have intentionally defective grantor trusts and self-canceling notes and all kinds of things that we can do so that you still have the benefit of your assets while you're alive, but they're not subject to estate tax when you die. And by the way, the family partnerships are a very important tool in reducing estate taxes.
Okay. Why?
Because
and how?
You can give away, remember, when you set up the partnership, you can be a 1% general partner. Let's say your spouse is a 1% general partner, and the other 98% you have as limited partners. And you can give away over time the 98% limited partnership shares to your children.
So they can be minors.
They can be minors, sure. And by giving them the 98% limited partnership shares, whatever that partnership is worth, 98% of it is out of your estate, but you still control it all because you're the general partner. The general partner has the exclusive right and responsibility to manage the partnership. And the children's limited partners, they have no voting rights. They can't outvote you. They can't vote you into a nursing home later on.
Declare you incompetent.
Exactly. Okay? So you control the assets in the partnership as the general partner as long as you're alive, but you've given away 98% of the partnership interests to the children. You haven't given away the assets in the partnership. You've just given them partnership shares, a piece of paper. But the law and the IRS recognizes that piece of paper and says that's no longer in your estate.
While we're on the topic, you always hear about people who in their later years they get sick and maybe they need to be in a nursing home, and then the nursing home wants to get paid and they look to your personal assets. How does all this fit in?
Well, if you put your assets into a limited partnership, they're protected from creditors, including the nursing home.
Now, under the new health care law, which I know they're still sorting out, I've read that the government has the ability to grab some of your money, I think, if they feel you need to pay for some of your services. Would this potentially protect against that as well?
Yes, if the government is a creditor, it's a creditor like everybody else, and it has to follow state law in trying to collect.
So which begs the question: why doesn't everybody do asset protection? Why doesn't
everybody buy life insurance? Why do people smoke?
Okay, well, so speaking of why do people get divorced, which leads to the divorce question in asset protection. How does divorce work with asset protection, and what can be done in terms of asset protection with a current or pending divorce?
Well, let me take the simpler question first. What can be done with a current divorce? Nothing. Under New York law, once one spouse files a complaint for divorce, both spouses are restrained from doing anything with their assets. Their assets are frozen. So whatever you're going to do, just like I said with regular asset protection against civil creditors, do it before you get served with the summons and complaint. Same thing with a divorce. It's too late after you get served. If you're concerned that there may be a divorce down the road, if the marriage is shaky, that's when you want to think about asset protection. Now, the question is, will the family partnership be enough to protect the assets? And the answer is maybe not. Because if the assets that you're putting into the partnership are marital assets, assets that you acquired during the marriage or that grew during the marriage, for example, the home, a business that you started after you got married, a bank account that you started after you got married, A court could say, well, these are marital assets in the partnership, so I'm ordering you to give your wife half of your general partnership share. So now she shares control with you. And if you've, in fact, given her partnership shares when you set up the partnership, then you've already done it. So the only real, absolute 100% asset protection for a divorce situation is, again, the offshore trust. Turn the assets to money and move them into an offshore trust.
Or I guess, form all the FLPs before you get married, and then at least you have
If you form the FLPs before you get married and put the assets into the FLPs before you get married, and your wife is not a partner in the partnerships, then the family partnerships, the FLPs, kind of act as an envelope to segregate those assets from the marriage.
Right, but what about the growth of those assets?
The growth during the marriage might be a marital asset, especially if the other side, the spouse, can show that she contributed somehow to that growth.
So the truth is, I guess there's only so much you can do in these situations.
Domestically, yes. With partnerships, yes.
How does the offshore asset protection play in the divorce courts? Do the judges give you a harder time? Are they more brutal?
Judges don't like it, but they can't do much about it if you did it right and if you don't have control over the trustee.
And then, of course, when you set up all that offshore stuff, then you also have to do all the reporting to the IRS to get
Absolutely.
Yeah.
We're not talking about hiding anything offshore. You're going to tell your spouse or your creditor or whoever that you have an offshore trust, because they're going to find out anyway, because you have to file certain tax forms. You will be responsible for paying tax on any income you earned offshore. We just spoke about that in the previous segment.
Okay. So in the last couple of minutes that we have, what are the common mistakes that people make with asset protection that gets them jammed up? Or what are the myths that need to be dispelled?
The two most common mistakes that people make, one is being an ostrich, putting your head in the sand and saying, I'm never going to get sued. I'm okay.
I see a lot of that too, yeah.
Sure.
Yeah.
Look, I had a family come to me to protect their assets, and their assets were very significant. Why? Because their son took the car out one evening, 4 or 5 guys in the car with him. Somebody was drinking a little bit, and they got into an accident, a bad accident, and 2 of the guys in the car got seriously injured and 1 got killed. Yeah. Well, the car was owned by mom and dad, so mom and dad got sued. Okay? Mom and dad were retired. They weren't even in a business or anything. They said, we're never going to get sued. We have no liabilities, but here you go. They got sued.
Yeah, and of course the emotional cost.
Right. And the insurance that they had, the liability insurance, wasn't nearly enough to cover a death and 2 very serious permanent injuries.
Right, because policy limitations.
Right.
Look, even if you have a $2 million policy, you don't, the first thing you get is a letter from the carrier that says, get extra counsel because it looks like you're going to have more than your coverage.
Sure. What the insurance company does in that case right away is writes a check for $2 million, says, here, I'm giving the plaintiff the $2 million right now, and we're out of here, and the rest is yours.
Right, and that rest could be very scary.
That's right.
Yes.
In this specific case, the complaint was for $15 million from one plaintiff, the boy who passed away, and I think it was somewhere about $7 or $8 million from one of the other injured plaintiffs, and over $10 million from the other injured plaintiff.
Wow.
The other mistake that people make is doing do-it-yourself asset protection, what you described before. Well, I'm going to put everything in my wife's name.
Right. I see. As an attorney who represents a lot of small business owners, I see a lot of that. Mm-hmm. And then I actually tell people that they may have to undo it just to avoid the the perception and the tax consequences of what they did.
I also see a lot of people who say, "Oh, well, I have my company or my assets in an LLC, and the lawyer, the business lawyer, or the real estate lawyer who set it up said that's enough for asset protection." And then I ask them, "Okay, who's the shareholder of the LLC? Who's the member of the LLC?" And they say, "Me." And I say, "All of it? Are you the 100% member?" And they say, "Yeah." And I said, "Guess what? There's no asset protection whatsoever there." The courts have held that a single-member LLC is a disregarded entity, and it's disregarded for all purposes.
But the same is not true for a single-member corporation. Is that correct? A single shareholder in a corporation?
It's not true for a single shareholder for a corporation, but it's very easy to pierce the corporate veil for a single shareholder corporation.
Right. So tricky stuff. So the bottom line is you really need to talk to an attorney and a tax accountant to integrate it all together.
Yes, you need to do proper and effective asset protection that works. You can't do it yourself. And you can't do it with an attorney who isn't a specialist in asset protection.
Oh, that's 100%. And I'm an attorney, and when people ask me, the first thing I say is, no, you got to talk to somebody who actually knows how to do this. The other thing is, I guess, in closing, is that you actually need to work with CPAs that actually understand the dynamics of asset protection. Because not all the CPAs understand, I mean, they should, but not everybody really understands the complexities of some of this stuff, especially when it's multiple FLPs and all kinds of different iterations. One last question. Why do people have their FLPs in other states other than maybe the place that they are residing or domiciled in?
Usually because it's cheaper. I mean, the law is pretty much identical in all the states, but one state... Well, let's take an example. New York, when you form an LLC or a limited partnership, in addition to paying the $350 or so registration fee, you have to publish in 2 newspapers of general circulation for 6 weeks a small ad announcing that you formed the LLC or the limited partnership. If you live in the 5 boroughs of New York, that could cost you $1,200–1,300.
Or more. Or I've seen it actually even more, yeah.
Right. Okay? Other states don't require publication. So by registering the partnership in another state, you save yourself the $1,200, $1,300, $1,400.
I also isn't there an annual fee in New York for the LLC fee?
Yes, there's a fee in every state, but in New York it's higher than in many other states.
All right. So with that, we're out of time. So for those who listened in, this is Ken Rubinstein, who's an asset protection attorney, estate planning attorney, tax attorney, and a real go-to guy. 212-888-6600, assetlawyer.com. This is Richard Solomon, Taking Care of Business, TCBRadio.com. Thanks for listening. We'll see you next week.
Whoa!